Alright, so ladies and gentlemen, welcome to today's video. Today we will be learning that what is bailment and what is pledge. So before we begin, we will be starting with the meaning of bailment. What is bailment? Bailment is defined under section 148 of the Indian Contract Act, where it is said that a bailment is the delivery of goods from one person to another person for some certain purpose upon a contract that the good shall, when the purpose is accomplished, be returned or be disposed of according to the direction of the person who is delivering them. Now in bailment, there are broadly two different parties. One is a bailor, another one is a bailee. So bailor we basically call the person who is giving the goods, and bailee is the person to whom the goods are given. We can take an example that X delivers his car to repair to Mr. Y. In this case, X is the bailor because he is the person who is delivering the good, means the car, to Mr. Y. And Y is the bailee because he is the person to whom the car has been delivered or the good has been delivered. And after that, we will have the essential of bailment. There are broadly 5 different essential of bailment. Number 1, that there should be a contract. In bailment, it is mandatory to have a contract. It can be an express contract or it can be an implied contract. Secondly, there should be delivery of goods. In bailment, the goods should be delivered from one person to another person. Thirdly, there should be a purpose. In bailment, the goods are delivered from one person to another person under a certain purpose. And number 4 is there should be return of good. In bailment, the good should be returned after that certain purpose is accomplished, or according to the bailee's instruction, it should be disposed of. And the last one is the possession. In bailment, the possession of the good changes. It goes from one person to another person. Now moving on to the next thing, we have the duties of a bailor. There are broadly 4 different duties which is classified under section 150, 158, 159 and under section 164. So these 4 duties of a bailor are: disclose known facts, bear necessary expenses, indemnity bailee, and the bound to accept goods. And after that, we have the duties of a bailee. The duties of a bailee are: take the responsible care or the reasonable care of the goods which is bailed. There should be no authorized use of the good. There should be no mixing of the bailor's good with his own good. There should be a return of the good, and to return any extra profit which is acquired from the goods bailed. And last but not the least, the termination of bailment. The termination of bailment can be done depending upon different situation. Number 1, if the purpose is accomplished. Example, Mr. X had given the car to repair to Mr. Y. In this case, if the car is done with repairing, then the purpose is already over, so the bailment will be expired because of the fulfillment of the purpose. Number 2 is on expiry of a stipulated time period. Means if the goods were given for a stipulated time period, for example 1 month, 3 months, 9 months, then after that time the contract of the bailment will be terminated on the expiry of such period. And number 3 is by notice, and last but not the least is by death, because a gratuitous bailment can terminate upon the death of either of the bailor or bailee, means either of the parties. Apart from all the 4 which I have mentioned, means the expiry of the fixed stipulated time period, then the fulfillment of the certain purpose of the death, or those, there is one more which we can say as the destruction of the subject matter. A bailment is terminated if the subject matter of the bailment, or there is a change in its nature of the goods which makes it impossible to be used for the purpose of bailment.
Pledge refers to transfer of goods from one person to another person as a security of repayment of debt.
For example, I require some amount of money, but I don't have it, and I don't want to go to the bank too. So I go to a local gold jeweler and I give my gold chain to him and take money on behalf of it. It's known as pledge.
In pledge, we mortgage a movable property like jewelry, stocks, and take a loan against it. In pledge, there is a transfer of possession of movable property to the lender. Pledge is covered under Indian Contract Act 1872.
So here, let's discuss the difference between bailment and pledge. The meaning of bailment and pledge. Bailment means the exchange of the goods from one person to another for a specific purpose, whereas pledge means the transfer of goods from one person to another for a security of repayment of a debt. The parties involved in bailment and pledge. In bailment, the person who delivers the goods is known as bailor and the person to whom the goods are delivered is known as an bailee. Whereas in pledge, the person who delivers the goods for security is known as pawner and the person to whom the goods are delivered is known as an pawnee. The right to sell the goods. In bailment, we don't have the right to sell the goods as there are very limited rights specified. Whereas in pledge, we have the right to sell the goods if the pawner fails to complete his repayment. Purpose. Bailment doesn't require a specific purpose. It can be done for the repair of goods or possession of the goods, whereas in pledge there is a specific purpose required, maybe for the promise made or the delivery of the goods for a specific purpose and repayment of the debt. The right to use the goods. The bailee can use the goods if specified in the contract, whereas in pledge, the pledgee cannot use the goods pledged. Let's talk about consideration. Bailment does or does not require consideration, whereas in pledge, they do require consideration.